And then I start, right? Or do you say something?
You may begin.
Good afternoon. We appreciate everyone who's joined us on the call today. And my name's Dana, and I want to introduce to you Stacy Cook. We're grateful that Stacy, a partner with Healthcare Department of Barnes and Thornburg Law Firm, is going to speak to us today about some HIPAA security and privacy issues. Stacy brings her experience as a former litigator, regulator, in-house counsel to provide a unique perspective in representing clients. She concentrates her practice on healthcare regulatory issues and privacy and security matters, including HIPAA. What may be of particular interest to you is that Stacy guides clients through the various aspects of HIPAA compliance, including drafting policies and procedures, drafting and negotiating business associate agreements, handling large and small breaches, and defending clients under investigation by the Office of Civil Rights. 3 quick things before we begin. 1, we are recording today's session. It will be available on IRHA's YouTube channel within a week. You can find this on the IRHA website on the events page as an archived webinar, or if at any point during the presentation you want to ask a question, use the Q&A function. When you hover your mouse over the screen, either at the top of your screen or at the bottom, this Q&A function should pop up for you. I will keep an eye on the questions and let Stacy know at the end, and she'll answer your questions today. So thank you, Stacy, for joining us. Let's begin.
Thank you, Dana. Good afternoon, everyone. I'm happy to be with you this afternoon to talk about the HIPAA privacy rule. Specifically, the HIPAA law is very broad, and so my presentation today is going to focus on the privacy rule and specifically what it says about sharing information about adult and minor patients, so children, with other family members. This rule, specifically with respect to sharing information about children, can get pretty confusing. So my goal is to break that down for you and hopefully make it a lot easier for you when you get those family member requests for information. So the first thing I'm going to do is lay a bit of groundwork and start with some basics of the HIPAA rule, which will apply to any question you have about sharing patient information with a family member. Then I'm going to get more specific and talk about the rules on disclosing a child or minor. By using the term minor in Indiana, I mean someone under the age of 17 or the age of 18. So sharing a child or minor's information with parents, disclosures of a deceased patient's information, and then we'll wrap up with disclosing protected health information to family members of an adult patient. And as a reminder, as you know, I'm giving this presentation generally. I don't know who's on the call except for, of course, great members of the IRHA. So this, of course, is not specific attorney-client advice. It's for your information purposes only. So on to laying the groundwork for the question of when can I or should I disclose information from one family member to another. One of the first things you need to be aware of is whether there's a permitted disclosure or a mandatory disclosure. So HIPAA is a law that we describe mostly as a permissive law. In other words, it allows you to do something It doesn't require you to do something. The vast majority of HIPAA exceptions are permissive. It says you may disclose, not you must disclose. However, the one HIPAA requirement, the most important one that is mandatory, is providing access to a patient to their own information. So when you're dealing with family members, you should know that sometimes a provider is allowed to share information with another family member, and sometimes a provider is actually required to share information from one family member to another. And that's important to note because a covered entity can be sanctioned when the HIPAA requirement is mandatory. When you are required to disclose one patient's information to a family member and you don't, you can be sanctioned. So it's always important to keep that in mind. Is this a required disclosure or is a permitted disclosure? And in that vein, as I said, the Office for Civil Rights, which is the federal agency that enforces HIPAA, announced just last year what it called a Patient Right of Access Initiative. And what the OCR said is we intend to vigorously enforce the patient's right under HIPAA to get prompt access, not just access, but prompt access, because there's a deadline under HIPAA for patient records. You know, in the past, the OCR, when they have brought sanctions against covered entities, it's primarily for data breaches. But last year, with this initiative, the OCR was coming out and saying, hey, we are going to focus some of our time on sanctioning organizations that do not comply with HIPAA to provide prompt access to patient records. And true to their word, they brought 2 actions in 2019 against 2 different healthcare providers for their failure to provide access promptly to the patient when requested. The first one was from Bayfront Health. That organization paid $85,000 and most importantly entered into what's called a corrective action plan, which means a specific plan to fix whatever went wrong. And this was a case where a parent requested prenatal records of their unborn child. So this is actually an example of a parent requesting the records of their minor's child. And at first the hospital, I guess, was unable to locate the records when the parent asked for the records. Then the parent's lawyer made the request and the hospital partly responded to that. But ultimately what OCR said was, look, when this patient requested the records, it took 3 different requests and 18 months to get the records. That is not acceptable. And so they were sanctioned. The second sanction was Corunda Medical. This was a primary care clinic that paid $85,000 and again entered into a corrective action plan, which I can guarantee is much more costly than the $85,000 fine. And the Office for Civil Rights said in that case that the patient made repeated requests and the facility did not respond in a timely manner. So again, OCR has said we're going to focus on this and we will sanction covered entities when they do not comply with HIPAA and provide a patient's records when the patient asks for their own records. The second, again, continuing and laying the groundwork, the second thing you need to be mindful of when you're thinking about providing a patient's records to their family members is something under HIPAA called a personal representative, or PR for short in slides. A personal representative is just, when you boil down to it, is someone who stands in the shoes of the patient. So if the patient has a personal representative, the covered entity has to treat the personal representative as if they are the patient. So if we talk about a patient's right to access their own records, if they have a personal representative, the personal representative has the right to access the patient's records. They are acting for the patient. A personal representative may be necessary in a couple situations. It may be necessary because the patient is considered incompetent under law, and that means that they don't have the capacity to make certain legal decisions. So one example would be an adult who is considered to be mentally incompetent, and there's a legal guardian that's been appointed. The legal guardian would be the personal representative. Another very common example of a personal representative is the parent of a minor child. So again, an individual under the age of 18 is not legally competent to make decisions about their health care and those types of things. And so a parent, and we'll talk about this more, can be a personal representative and many times is the personal representative of the minor. A personal representative may also be selected by a competent adult, and we see this most commonly, with a power of attorney or healthcare power of attorney. And then finally, if a patient passes away, a patient is no longer alive, they may have a personal representative as well. So putting that together, putting those kind of two concepts under HIPAA, the mandatory versus permissive disclosure and the personal representative, when a family member also happens to be a personal representative of the patient, disclosure is required, not just allowed, but required. When a family member is not a personal representative, then the next question you ask is, does HIPAA allow the disclosure? And if HIPAA allows it, it's permissible. Okay, so with that groundwork, we're going to go right to the rule on disclosures of minors' information to parents. And I will tell you at the outset that this is unfortunately more complicated than I would like it to be. Unfortunately, HIPAA doesn't say if X, then Y. It basically says if A, then B, then C, then Y. So I'm going to go through for you what the rule is. So we're going to go through A, B, C, D. So you know the basis of the rule in case you have a complicated situation, and that will help your understanding of how you work through it. But be assured that at the end, when I go through this, I'm going to wrap it all up and give you a slide that says, okay, I boiled this down to these are the questions that you ask, and if A, then B. Okay? So with that, we'll start. So the general rule is that when it comes to a minor or a child, the parent will be considered a personal representative, which means they stand in the shoes of the child, unless state law allows the minor to consent to the service. The minor consents and does not request that the parent be treated as a personal representative. Okay, so the minor under law is able to have the service themselves, and they say, yeah, and they come by themselves and they don't ask you for their parent to be involved, then in that case, the parent is not a personal representative. A parent will not be a personal representative of a minor, as noted in the second bullet point, if someone other than the parent is authorized to consent for the service and consent. So an example of this would be a mother has had parental rights terminated and a foster parent has the authority to consent and consents. Then the mother, the biological mother, would not be the personal representative of the child for HIPAA purposes. And then the last one is if the parent agrees to confidentiality between the minor and the provider. So this would be an example of a parent calls a practice and says, my daughter is 16, I am authorizing her to come to you to talk about fill in the blank, birth control. I don't need to know. I don't want to know. I think she's at the point where I'm authorizing you to have a confidential discussion. Okay. These are the three situations where the parent will not be considered the personal representative of a minor. And then I put at the bottom of the slide, but see more, because again, there's more to this rule. Even if the parent is not a personal representative, HIPAA also defers to other laws that expressly addresses the parent's ability to get the information. So what HIPAA says is, okay, let's say in the second scenario where the mother has lost parental rights and she's not the personal representative. HIPAA says you providers should look to see if there's other state or federal law that specifically says in the case of a foster situation, the biological mother gets access to the records. Now, I will tell you, I haven't done just an exhaustive search over every single healthcare law that could ever occur, but generally in Indiana, there really aren't sort of these other laws. So as a general rule, the first slide, the previous slide applies. There's not a lot of other extra rules. The second exception is the safety of the minor, and this is likely the most common, honestly, that providers would encounter. So HIPAA says even if the parent is a personal representative, the provider can decide in a case-by-case situation not to treat the parent as the personal representative if the provider believes, so they are saying it's up to the provider to make this determination. The minor has been or may be subject to violence, abuse, or neglect by the parent. Excuse me. Or the minor may be endangered if the provider treats the parent as the personal representative and the provider determines that it is not in the best interest of the patient to treat the parent as the personal representative. So again, even if otherwise the law would treat the parent as a personal representative, if the provider decides again that, for example, that maybe the parent is physically abusing the child, they can decide not to treat the parent as a personal representative. So again, because the first part of that really depends on whether the minor can consent to their own health care, I've provided this information on what Indiana law says about whether the minor can consent. So again, just a reminder, HIPAA says if the minor can consent for the service, they do consent, and they don't wish for their parent to be involved, then the parent is not the personal representative. So in Indiana, and this applies to non-pregnant patients, a minor can consent to their own care for the following. If the minor suspects or has been exposed to a venereal disease, the minor can consent to get evaluated and treated for that. So a 14-year-old comes in and says, I think I have a sexually transmitted disease. The parent does not need to consent. The child can get treated, evaluated, and treated, and the parent doesn't need to be involved. A minor can also consent if they are married or have been married, if they are currently in the US military, if they're emancipated, which is a legal term meaning they have gone to court and a court has ordered that they can live completely separately out from their parents, which is pretty rare these days. Or the last category is if they are at least 14 years old, they're living apart from their parent and an adult, and they are not dependent on the parent's support, and they're managing their own affairs. The most common example of this that I have found, unfortunately, is a homeless child. So somebody who's at least 14, they're living on the streets and they are managing their own affairs the best they can, then that individual could consent to their own healthcare services. A specific note here, Indiana does not specifically authorize minors to consent to contraception. And I always, when I get clients, when I tell clients that, they always say, "Are you sure?" And usually I say, you know, I always say, yes, that's what I said. There is no specific provision in Indiana that says a minor can consent to contraception, to either be evaluated for or get contraception. It would have to fit under one of the other exceptions. I would note, because people say, well, what about Planned Parenthood? Facilities that receive Title X federal family planning grants and money are in a specific category. They're allowed to treat certain minors for contraception under that law. That does not apply to private providers. Again, it's only Planned Parenthood. Indiana has a fairly new law on when minors can consent when they are pregnant. And this went into effect in 2019. And that Indiana law says a minor can consent to services for their pregnancy, delivery, and postpartum care if the minor is at least 16, is pregnant, in labor, or within 60 days of postpartum. And as long as before providing care, this could be either at the first appointment before anything's been done or before the first appointment, the provider makes a reasonable effort to contact the parent or guardian to get consent and documents that attempt. And if they're not able to contact them and the pregnant minor comes in again, they need to make one more attempt. The provider needs to make one more attempt to contact for consent. If all those occur and the parent either says, no, I'm not giving consent to my child, for my child to have treatment from you, or if they just can't be reached, the provider can go ahead and treat because the minor has the ability to consent for their own treatment, again, for pregnancy, delivery, and postpartum care. So again, if we boil that down in Indiana, determining the first step, if you get a request from a parent or are trying to decide, can we or should we share a child's records with a parent? Usually kids have two parents. The first question you should ask is the parent a personal representative? And then you ask, to determine that, you ask, can the minor consent to their own care? Is someone else authorized to consent? Did the parent agree not to receive the information? Or does the provider reasonably believe that the child has been abused or neglected or will be endangered if the information is shared? And is it in the minor's best interest not to treat the patient as the parent as the personal representative? If you answer A, B, C, and D, if the answer to those questions is no, then the parent is the personal representative and the provider can disclose and must disclose if the parent requests it. So in other words, if a child comes in and they cannot consent to their own care, which is question A, question B, no one else is authorized to consent for them. The parent did not agree to not get the information. And if the provider does not believe that the child is in danger, then the parent, again, is the personal representative and has to be treated as such and has the right to their child's information. If the answer to even one of the above questions is yes, then the parent is not to be treated as the personal representative. And the provider in this case can exercise his or her discretion and decide whether or not to share the information. The provider is not required to do so, but they may do so. Okay. And then another thought on disclosing minor information to parents. As I said, you know, most children have at least two parents. And Indiana law with respect to divorced and non-married parents is that both custodial and non-custodial parents have the right to their child's information, unless a court order limits one parent's right of access and the provider either knows about it or has a copy of it. So let me kind of break that down. When I say custodial and non-custodial parent, a custodial parent means that the child is living with that parent. That's usually the term that the child has custody. It's kind of an outdated term, but it means that the child either solely lives with that parent or primarily lives with that parent. So if a couple is divorced and let's say the father only sees the kids on the weekend, the father still has equal right to access the child's medical information. And the exception is if there is a court order limiting that parent's access. Not just a court order, but either the provider has been told that there's a court order or knows and has a copy of the court order. So general rule is both parents, again, whether they've ever been married or not, have access to their minor's information, their children's information. Okay, so we've talked about minors, and now I'm going to go to what do you do when a patient has passed away and multiple people or one person is asking for a copy of their records. Who is authorized to get that information? HIPAA says that you look to state law. That's the basic rule. So it says if your state authorizes a particular person to act on behalf of the patient or the patient's estate, if they have a will, then you treat that person as the personal representative. Indiana law, unlike the minor sort of issue, this is pretty straightforward. So Indiana law gives authority for one person to act as a representative of a deceased patient by priority. So I'll go through that. So Indiana says first, if the estate has a personal representative, so a judge had said, you know, Stacy Cook, you're gonna be the representative of your father's estate, then I would be the personal representative also under HIPAA. If there is no personal representative of the estate, and that could happen typically when someone doesn't have a will, then you look to the spouse. So is there a spouse of the decedent? If there is, then the spouse is the personal representative. So again, I call my spouse's provider and I say, my spouse passed away, I would like a copy of his records. And the provider needs to treat me as the personal representative, and I have under HIPAA an absolute right to those records. If there is no spouse, then you look to a child, and here I'm talking about a child who is an adult. So that would be the case where I call and I say, my father passed away, and I would like a copy of his records. And if my mother is no longer living, then I would be entitled, and there's no personal representative, then I would be entitled as the adult child. Or it could be the parent of an incompetent or child. So that would happen, for example, with, I guess, a non-married couple, and there's a child who is, 13 years old, and the child's mother passed away. The father could say, I'm the personal representative for the child. I'd like a copy of the records. And then the last is the court-appointed guardian. And so to clarify here, Indiana law doesn't say all of these people have the right. It's by priority. So if there's a personal representative, then only the personal representative is considered the personal representative under HIPAA. You don't also give that right to the spouse and the child and the guardian, okay? So now we'll move to disclosures to family members and friends even of adult patients. We've talked about the personal representative in the cases where there's an incompetent adult, when the patient has died, or when there's a child. This actually covers situations where there is no personal representative. So the first situation HIPAA says is you've got a situation where the patient is actually present and they are competent. And what HIPAA says is if the patient agrees or does not object, the provider can share what that family member or friend needs to know, given their involvement in the patient's care or payment for care. And so let me kind of break that down. So patient is present and competent. It means, they're an adult, they're able to make decisions about their health care. Present doesn't mean that they have to be physically present. It means they could be on a phone call, on a telehealth visit, and that type of thing. And as I said, the second part of that is the patient either agrees or does not object. This is a situation where the patient could agree verbally. It's not meant to be the patient has to sign a written authorization, okay? So a couple of examples of these are a patient calls to the clinic with the daughter on the line and says, I'm asking about a particular charge that I received for an office visit. I don't hear really well, and so I would like my daughter to be on the line. She's going to be on the line. And she doesn't even need to say that. She could just say, I have a question. My daughter's also on the line. Here's my question. In that case, I think it's reasonable to assume that that the parent is okay with the daughter having that information, okay? Another example is a patient brings a neighbor to a procedure, to a clinic, let's say an epidural or something like that, where they get some moderate sedation, and it requires the patient to have a driver. Many times clinics will say, you have to have a driver. You will not be okay to drive home. We won't do this procedure unless you have a driver. Let's say a patient brings a neighbor as the driver, and again, the patient is still a little woozy or whatever, and there are discharge instructions. It's important that you fill this medication. It's important that you do X, Y, and Z. If the patient brings that neighbor, again, it's reasonable to assume and to determine that you can share that information, that discharge information, with the neighbor to make sure that the patient gets that information. Another example would be, again, the patient bringing a friend to a procedure, and the friend picks up the medications that are dispensed upon discharge. Those are situations, again, where the patient is present, competent, the patient is not objecting to that information. Now, of course, the opposite is true. If, patient is in the hospital, doctor comes in, patient says, this is my neighbor. I would prefer that my neighbor please leave before we have our discussion. Then you obviously wouldn't share information with the neighbor in that situation. And then the second situation under HIPAA, and these are what I call common sense situations. Not every provision under HIPAA is a common sense situation, but these actually are. So the second type of category is the patient is not present or is incapacitated, and the provider determines that it's in the patient's best interest to share the information with a friend or family member. In that case, the disclosure is permissible under HIPAA as long as you share only what the person needs to know about the patient's care or payment for the care. So an example of this would be a neighbor brings an unconscious patient to the hospital. He says, I was visiting my neighbor, she passed out, or she's unconscious, here she is, and they leave. A man calls an hour later and says, I'm the brother of Susie. Susie's neighbor called me and said that Susie passed out. I'm really concerned. I want to see how she's doing. Where is she? I want to come visit. If you determine that that's in the patient's best interest, then it is permissible to disclose that. Another example is, the son of an elderly patient calls about a bill and says, I'm helping my mom trying to decipher what these charges are. It is, again, reasonable unless you know of some reason the mother didn't want to share that information. It is reasonable to share that. I would also note that in this situation, verification is not required. A provider is allowed to reasonably rely on the person's statement when they're representing to you, I'm the brother, and so forth. When it comes to disclosures to family members, as we've been talking about, there are other HIPAA exceptions as well. And one thing that I thought would be helpful to you is OCR published fairly recently, it's been in the last couple of years, frequently asked questions about sharing mental health and substance use information with friends and family members. Unfortunately, this is common in this day and age of the opioid epidemic, so I thought it would be helpful to talk to you about these. So the FAQs note, if a patient, for example, has an overdose and they are incapacitated, the provider can notify the family member, a family member of the patient's location and general condition and that type of information. So in a situation, common situation is an adult child, let's say a 21-year-old, is brought to the hospital and has overdosed. Family members may be wondering, Billy hasn't shown up to work, where is Billy, things like that. So a provider can call a family member and say, Billy was admitted, Billy had an overdose, here's where he is, he survived, some basic information. The FAQ notes that the patient's decision-making incapacity may be temporary or may be longer term. So in other words, if the patient regains capacity the next day, then the patient needs to have the opportunity to decide if they're going to agree to those further disclosures or to object. So the conversation would be the next day, Billy comes to, and so the discussion is, Billy, we needed to notify your family so people knew where you were. We shared that with you. Would you like us to continue sharing your health information with your family or not? That would be the discussion. The FAQs also say, keep in mind that there is an exception, a general exception, not just to family members, but anybody, to prevent or lessen a serious and imminent threat to the safety of a person or the public. And HIPAA says that we are going to defer to the provider's judgment in determining the nature and severity of the threat. So I believe one of the examples would be, a patient who's been in substance use treatment and a provider believes that they are no longer abstinent and that there is an immediate threat, then they may determine that it's reasonable in that case to notify a family member of the situation. And then the last thing I thought would be helpful to talk about is a question I get quite often, particularly when it comes to what about insurance claims? And this is particularly relevant now that now with the Affordable Care Act, that insurance covers a dependent child up to the age of 26. So in that case, you have an adult who is perfectly capable of consenting to their own health care, which means their parent is not their personal representative, and they may want their health care to remain confidential. Keep in mind, as you probably know, that insurance information is typically sent to the primary, member who has the health plan, and that's typically the employed adult. And this could also count for spouses as well. A provider is generally permitted to submit a claim. Some states have different laws. Indiana is not in that category. And so what I typically tell clients is, if you have a minor who, again, is able to consent, the parent is not considered a personal representative, and the child does not want that information to be disclosed, then you should have a discussion with the minor about, okay, what do you want to do with your insurance? Because if you want insurance to pay for this, we submit this to insurance and then it's out of our hands, and as you can imagine, it will likely go to an explanation of benefit will likely go to your parent. So how do you want to handle that? Again, knowing that that is out of the provider's control once the provider bills for the service. So I just recommend, having that conversation with whatever patient, in a situation where they are competent and they do not want their information shared with any other family members. All right, so that is the substance of my presentation today, and now I'm happy to open it up for questions.
I do not see any questions submitted at this time. Does anybody have questions? Well, I don't see any typing either. So I guess if we have no questions, we'll wrap up the webinar. So